Companies Act, Section 227, Protection from Disclosure, Safeguarding Legal Privilege and Banking Confidentiality During Investigations. Section 227 of the Companies Act, 2013, establishes important safeguards during the course of inspections, inquiries, and investigations conducted under Chapter 14 of the Act. This chapter deals comprehensively with the powers of regulatory authorities such as the central government, the Registrar of Companies, the National Company Law Tribunal, NCLT, and appointed inspectors to conduct thorough investigations into the affairs of companies and other related entities. However, while enabling such powers is essential to promote transparency and accountability in corporate functioning, Section 227 introduces critical limitations designed to preserve the sanctity of privileged legal communications and to uphold confidentiality in banking relationships. These limitations ensure that certain categories of information are protected from mandatory disclosure during investigations, thus maintaining fundamental rights and professional obligations. Scope of application. Section 227 specifically applies notwithstanding anything contained in Chapter 14 of the Companies Act, 2013. It carves out two categories of information and relationships that are exempt from disclosure obligations during investigations initiated under this chapter. These are privileged communications made to legal advisors in their professional capacity, and confidential information about bank customers unrelated to the investigation. Protection of legal professional privilege. One of the foundational principles of legal systems around the world, including India, is the doctrine of legal professional privilege. This principle ensures that individuals and entities can seek candid legal advice without fear that the communication will later be disclosed or used against them. Provision under Section 227(a). Nothing in this chapter shall require the disclosure to the tribunal, the central government, the registrar, or an inspector appointed by the central government, of any privileged communication made to a legal advisor in that capacity, except with respect to the name and address of the client. Interpretation and implication. This clause confirms that legal professionals, including advocates, solicitors, and in-house counsel, are not compelled to reveal the content of any confidential advice, correspondence, discussions, or documentation provided to their clients in the course of their legal representation. This immunity continues even when such legal professionals are called upon during formal investigations under the Companies Act. The only exception to this protection is that the legal advisor may be required to disclose the name and address of their client. This narrow exception exists to ensure that the authorities are able to identify the client linked to a transaction or legal advice, but without compromising the nature and content of the communication between them. This provision supports the ethical and legal responsibility of lawyers to protect their clients' confidentiality, while ensuring accountability and traceability in cases of potential misconduct. 2. Preservation of banking secrecy and customer confidentiality. Banks are custodians of sensitive financial data and are under a fiduciary duty to maintain the secrecy of their customer accounts and transactions. Section 227(b) ensures that these duties are not infringed upon unnecessarily during corporate investigations. Provision under Section 227(b). Nothing in this chapter shall require the disclosure by the bankers of any company, body corporate, or other person, of any information as to the affairs of any of their customers, other than such company, body corporate, or person. Interpretation and implication. This clause protects bankers from being compelled to provide information regarding other customers who are not the subject of the investigation. In essence, if a particular company or person is under investigation, only their specific account information can be accessed or examined. The accounts, transactions, and personal financial data of unrelated customers, even if they are clients of the same bank, are strictly off-limits to inspectors or investigating authorities. This provision ensures that the right to financial privacy of other individuals or companies is not violated simply because their banker is involved in an ongoing investigation into a different customer. It acts as a vital safeguard to prevent fishing expeditions and to limit the scope of the investigation to only the relevant entities. Legal and ethical justification. Both clauses of Section 227 are grounded in principles of natural justice, legal ethics, fiduciary duties, and public interest. They are designed to prevent misuse of investigative powers by ensuring that irrelevant parties are not dragged into inquiries without cause. Encourage companies and individuals to seek legal advice freely, promoting compliance and responsible corporate conduct. Protect public trust in legal and banking institutions by affirming their responsibility to safeguard confidential information. The section also aligns with other legal frameworks, such as Section 126 of the Indian Evidence Act, 1872, which outlines protections for professional communications between legal advisors and clients. The Bankers Book Evidence Act, 1891, and banking regulations under the RBI Act, which emphasize confidentiality obligations of financial institutions. Judicial recognition. Indian courts have consistently upheld the principle of legal privilege and banking confidentiality. The inclusion of Section 227 in the Companies Act explicitly codifies these rights in the context of corporate investigations, thus shielding professionals from arbitrary or excessive disclosure requirements. For more details, contact us.